Hi. This month's topic is coincidental with the release of our new web page dedicated to the topic of wrongful death suits. In Washington state, as in most states, the cause of action that one might have for the negligent act that results in somebody else's death is one that's created by statute. In other words, this right just doesn't exist on its own through what we call the common law, but it's a creation of the legislature. In Washington, this is a very old statute created during more agrarian-based time, really based on the concept of children who stay at home and work in a farm setting. And as a result of that, it's a little quirky, but let's go through the basics. The basic gist of it, again, because it's created by statute, this means that only the claims set forth in the statute can be brought, and only by the people who are set forth in the statute. All claims must be brought through the estate, which has to be created, of the wrongfully killed human being. Once the estate is created, the estate has the right to bring suit, as do beneficiaries of the estate, but not all beneficiaries. So the quirk in Washington law that's interesting and results in some unfair outcomes is that if the person who has been killed is an adult over the age of 18, but not married and without children, then that person's siblings and parents do not have any cause of action to bring for their loss of their son or brother or daughter in that setting, unless one or more of them was financially dependent upon the work of that person, and that's of course very rare. So once your child turns 18, if they were to be struck by an automobile and killed while crossing the street, there probably is not an awful lot that can be done under our current legal system in terms of bringing a suit, because the statute simply doesn't provide for adequate damages to justify doing that. If your loved one is over the age of 18 and developmentally disabled and doesn't bring in income and is unlikely to have a family, then again, they're really without meaningful rights under this statute. Wrongful death cases are serious. Any cause of action for injury that the person had prior to their death is still an eligible cause of action to be brought on behalf of the estate. Generally speaking, it's a 3-year statute of limitations. This means you have to either resolve your claim amicably or file and properly serve a lawsuit within the 3-year period from the date where the incident, where the negligent incident occurred, or you lose all rights to compensation. Once in the suit, if you have the appropriate heirs to bring it, so for example minor children on behalf of a deceased father or mother, you can bring claims for lost income and loss of companionship and you know, the actual losses that occur in that setting. These are difficult, usually hard-fought suits, because they quite often are very emotional and have sufficient financial value for insurance companies to want to put up a fight. They also know that most people don't want to go through a suit in those circumstances, and so they will often put some pressure on people to take lower offers or not resolve their claim in a fair manner. We very much enjoy fighting for people to make sure they're treated fairly in these circumstances, and our consultations are free. If you have any questions or concerns or think you have the possibility of such a claim, please feel free to give us a call and we'll be happy to evaluate it for you. Thanks so much.